We can just go to the next slide immediately so we can start there. Tveter Kløvfjell is by Norwegian standards, small, medium-sized law firm. We are some 20 plus people working here. And we are coming from a place where we specialized in criminal law and immigration law. But over the last 5 to 7 years, the company has expanded into new areas of business. So now we are also focusing on very specific groups where we see that there is a need for legal aid, but where the threshold to ask for that aid or to get assistance is somewhat higher. So we have diversified our staff, and we have lawyers from different parts of the world with very different linguistic skills, so we can cater to a huge variety of clients, and of course in a huge variety of areas of expertise. Myself, my name is Steinar Fretheim, and I've just been with the company for half a year. But as you might have noticed, I'm not a teenager, so this is my kind of second career. I'm originally a Master of Science in Business and Economics holder, and I've been an entrepreneur for 20 years within fintech and clean tech, and I've been everything from CFO, CLO, CEO for listed companies down to startups. So I know everything about how to operate small and medium-sized businesses up to the big multinationals. And I've also been working and living in 7 different countries. So I'm very accustomed to the challenges and the questions you have here today from living in other countries and meeting the same barriers frequently when it comes to entering the labor market. So if we do one ahead now, Cassandra.
Yeah, I am trying.
Okay, there we are. So this is just to kind of give you a quick outline. As I said again, we changed the strategy a few years ago. So now we have dedicated desks working with dedicated countries based on the staff we have on board. Cassandra actually being a core member of this team. We have a Lithuanian desk, so we're catering to the Lithuanian community in Oslo, which is the second largest one. We have a Latvian desk. We have a number of chambers of commerce with whom we cooperate. Myself, I'm here because, well, one of the reasons I'm here is I'm extensive experience from Germany after having living in Germany and Switzerland. So linguistically and culturally, I'm there. We have the same with Poland and Romania and China as well. So this is just kind of to give an input about where we are and where our focus is when it comes to expand our services. And it goes both ways. It's both for Norwegians working abroad, Norwegian companies going abroad, but also from companies and people from a number of countries working in Norway. So yes, please, Cassandra.
Yeah.
And again, we have a wide area of expertise, which is not uncommon in Norway. Also because quite frequently, some of these areas of expertise follow each other. So in for private clients, people like you, for instance, we have everything from criminal law and immigration law and social insurance law, and of course then, as we talk about today, labor law. We also do cater to corporate clients, so we kind of know both sides of the table. And so just Tuesday this week, I was in court with a client for 8 hours in a labor law case, where then of course I was representing the employer. So we also do have a lot of corporate clients, and then we do also cater to these areas of expertise which are listed here, which typically are, again, labor law, but also contract law, bankruptcy, company formation, and so forth, which kind of tend to integrate. It's not like you just need one kind of specialty. You need typically more when you want to have someone like us on board. Please come up. Thank you. So today we're going to talk about labor law. So we had brainstorming here with Jyoti a few weeks ago about what to talk about, because I would like to talk about what is of interest to you guys. So I hope that we have somewhat nailed it down. So we're going to focus on topics starting with a work contract. That is when you get a job. How does that work? What's important for you as an employee when you do that? We're going to talk a bit about taxes and social contributions. Necessity of any modern state. We can like it or not like it, but taxes is part of what we have to relate to. Then working hours and overtime is a very frequent question, and comes up all the time when there is disputes. That's always a classic. Salaries, what is a fair pay? And that might be a bit surprising to some, but we're going into that topic a bit. Then, of course, another classic, termination of employment, especially when it's not voluntarily. And that is, in this case, of course, when the employer says, we do not need your services anymore. How does that work? And then we have labor protection law, which in Norway is very strict, especially for, of course, for the employer. But it's convenient to know a little bit how it works. We can talk about sickness and sykepenger, which is called in Norway, which is your compensation when you get sick and you have your social insurance, which is in Norway is called NAV, kicking in. Vacation, also a topic popping up from time to time. And then finally, disputes. How does it work when there is a dispute on anything between the employee and employer? So let's go on with the work contract. So anyone coming to Norway for, yes, let me go back again, hopefully.
All right.
There we are, thank you. Oh, we dropped one here. We lost one here. Okay, but we can take it anyway here. Work contract in Norway, it's obliged to have one by law. So you're supposed to have a work contract, and they will check it out if they go around. You have the unions in particular in the summertime, especially when lots of youth are around, they will go and see if people have work contracts. But don't worry, it's the employer who is having the problem if you don't have it. So it's not like you have to go around and worry for yourself. And the way it's organized, if there is no employment contract, then you're assuming that the regulations of the law are kicking in, and whatever establish a de facto work relationship is going to be considered to be a working contract. And then if there is none, then we just use the provisions of the law and of jurisprudence. So what I tell my corporate clients is that it's actually just as much in their interest to have a working contract as for the employees. Because if not, there are lots of things you're going to be subject to, for instance, how to manage overtime and whatnot, if that hasn't been taken into the work contract. But anyway, it's always a good idea to have it, because it's kind of takes away uncertainties about how much you're going to work, what you're going to be compensated, how much vacation you're going to have, to what bank account you're going to have your money, and so forth. So a general thing is that work contract, go for it, period. And if you don't get it, ask for it. And if you still have a problem, then call us or someone else in a similar profession, or union for that matter, because you're entitled to have it. And if the employer is kind of commenting about, oh, it's complex and it's bureaucracy and whatever, there is a free contract which is made by the Altinn, which is kind of the national registry for companies and taxation and whatever, where you can have it both in English and Norwegian, free for downloading. And you know this contract is compliant with the what is required by law. And you can just fill it out, sign it, and use it. So you don't have to go to us to make a contract for you. And so there's no reason for any employers, sorry, not to give you one and blaming extensive work or bureaucracy, whatever. It's actually not that complicated. But again, if you do have issues there and you don't get it, just give us a call, and normally it will come rapidly when we give them a little notification. So the heading in Norway, and now we're on to taxes and social contribution fees, is that for everything you want to do here, you need a D number or a person number. And of course, if you have been in Norway for some time, then most likely you have one of these. But if you don't, then you will need one of them, because you can't have a bank account without, you can't have benefits, you can't report. Everything you want to do in Norway requires you to have a D number or a person number. D number is kind of provisional one. It's one you get when you get here and you're staying for a shorter time, but you need a job or whatever. And there are different ways of getting it. If you just need it for a bank account, then the bank will actually cooperate with you. But for you who are going to work, then the tax authority have a special office in 42 places where you go and you meet up, because you have to identify yourself. And in Oslo, that is, you go online, you find the address. It's one specialized. It's an office specializing in foreign workers in Norway or in Oslo, and you have the same in Bergen and whatnot. So when you go online, you can just Google it, and there were 42 different places. And again, in Oslo, there is one specific office just for this purpose. And you go there, it's a bit of time waiting, but then you have the D number depending on, or down the road, you will also get the personnummer, which is basically the same, but then it's kind of fixed and final for you. And that will follow you literally to the grave. It will never be changed. So having that, you can apply for a skattekort, which is basically, depending where you're coming from, payroll tax, tax deduction, prepaid tax, whatever. It's got lots of names. But in Norway, when you have a salary, your employer is obliged to make a deduction on the payment. So you're getting your net salary based on a kind of assumption of what you're going to pay in taxes. And if you don't have this card, he will have to withhold 50% of your salary and send to the tax authorities. And most people won't pay 50% tax. That normally is a rather substantial salary. So that just means that you're going to have money which you won't see until a year and a half from now, when you have the tax returns finalized and you get the money back in a year and a half, typically in July, August, the year after. So for everybody, it's like important to have the right deduction. And what you do is, again, you go online. It's a very multi-language service, and you just fill in everything which comes up, which is salary, and if you have loans, interest, cost, whatever, they will calculate a tax rate for you. And this is it's not final. It's just kind of a calculation based on your information, and you send it to your employer, and then he will use that for deducting tax. So this is in your own interest. So it's kind of, there's no point in skipping this part. The only thing will happen is that you pay more tax than you have to here and now, and you will get it back, but it will take a year and a half. And for most of us, that's not something we like to do. Annual tax reporting, and skipping to the last one first. Yeah, you do have to do it every year. And if you don't do it, they will just make what is called a calculation based on whatever information they find. And that's normally not to your benefits. And of course, there is also fees to pay if you're late and all that stuff. So the annual tax reporting is typically due end of April. It's all online, so it's not very complicated. And it's also, nowadays, it's also kind of, if you have what is called silent approval, it means that you don't actually have, if you're just an employee, you can actually just, it will be, if you don't do anything, they will just take the numbers they have received. But if you do other things, that's when these things come into question, where they will kind of give you some extra taxes and whatnot if you don't report it. The point is, they're basing their reporting on what they know, and frequently there are lots of deductions they don't know about. So always recommend my clients to go in and check it, just to check everything is there, because you can be pretty sure they know everything about the income. So it's the deduction side, which is to your benefit, which is important to take care about. So annual tax reporting, even though you actually, if it's just salaries, you actually don't have to do anything. It's most of the time, go in, have a look, see if you have everything. And if you're certain, just consult with some people who knows about. For instance, you can call us. We know a little bit about tax. And in that connection, I reckon quite a few of you are also commuting. You're not having your fixed residence in Norway. Perhaps you're coming to Norway, you're working, and then you commute up and down, for instance, from, we have clients from Poland typically working in the construction industry. And then these deductions are very important to have. There is also a regime where you have a simplified taxation for a period of time, where you have a kind of a gross taxation, you get no deductions. And for some people, that can also be of relevance, but that's kind of, if that's makes sense or not is up to the individual case. For some, it's a good deal. For some, it's not. And for the rest of us who are kind of having normal taxation here, it's just, again, this is a deduction you are entitled to, and you have a per kilometer deduction, you have a per day for extra costing, whatever, and it's typically when you have family at home. So that's kind of the classic. You have a family at home, you come to Norway to work, and you travel up in and out of Norway. And it can amount to quite a lot of money. We're talking about tens of thousands of kroner a year in deductions, and for most people that's worth of it. It has to be said though, it has been reduced in value over the last years, but with the change in government coming in last fall, it's most likely going to be a bit more profit again for the taxpayer. So then we slide over to the next page. Thank you. Yeah, working hours. This is a classic. everybody's heard about 7.5 hour a day, which amounts to 37.5 hour a week. The general rule is actually 40 hours a week. And then there's always a gray zone if lunch break or not is included and whatnot. But frequently there is a conception that the moment you're working 1 hour more, then it's overtime. And it's depending on your work agreements and whatnot. But the general rule when it comes to overtime is that if you work overtime, you have to be compensated. And it is very, very important to think about that when you have your contract, because the law gives you 40% overtime compensation. So you get 40% extra on your salary. But in many areas, you have a much more beneficial agreement for that particular, for instance, construction industry, or you're working in an area where you're having a tariff, then it can be 100% or even more. So it's depending a bit of your profession, and it's depending a bit on what kind of position you have. If, for instance, if you're considered to be having a managerial position, then you're considered not to be paid compensated with overtime. And there's also a provision for special independent positions. And I can say immediately, this is a provision that is abused by the employers, because it's then you kind of skip the problem. You don't pay overtime. And frequently, if you're not a manager or you're having a very independent job, then most likely you are not going to be subject to this exemption. But again, then check out with someone like us or whatever to find out if you're in or out, because we're talking about money. And this can amount to quite a lot if you have a lot of work. What is also important is that we have a strict regulation how much you're allowed to work. And this is where most people are oblivious or ignoring it or whatever, especially the employers. In Norway, the maximum per week is 10 hours. That's 2.5 hours a day. So if you work like 10 hours a day per Monday, Friday, then you reach the limits. Is not allowed to work anymore. And this is for health reasons. Same per month, 25 hours. That's maximum. So you can't even work 2.5 hours a day for a month. And per year is 200 hours. And that is not a lot, because a normal working year is 1,650, 1,700 hours. So we're talking like 10, 12, 15% maximum, and then you're at a threshold. There is, however, an exemption. If there is a union involved, you can apply for an extension up to 400 hours. And there are also other provisions which are available for those who are working like offshore and whatever. But then again, that's a case-to-case basis. You have to assess it. So the general rule is actually what you see here, and this is surprising a lot of people. And again, the problem is for the employer, and we'll get back to that a bit later. But the controls and the consequences can be quite draconian for an employer. But again, I know there's a lot of employees who want to have these kind of work intensely for 2 weeks, then go home for a week. It's what we call offshore shifts. It's typically what you have if you're working offshore in the oil industry. Then you're working like 12 hours a day, 7 days a week for 2 weeks, and then you have 4 weeks off. And this is something which other people like to have in other industries as well. But however, it's a bit tedious to have it done properly. So again, if this is a question which is relevant for you, then have a check on that one, because it is rather limited. People are very surprised by this. And again, it's agreement is your first level of settling how much you have to be compensated. And I said again, if there is no provision for that in your work agreement, or if you don't have a work agreement, then it's by the law, which is 40%. And then again, as I said, in some areas there is a tariff, or a tariff has been made general, which means that it doesn't matter if you're organized or not, it applies for you as well, and typically construction industry.
So time you can do per year by law.
Yeah. So if there is a question, we can skip in, and just note them and take them afterwards. We're trying to have a Q&A afterwards. So again, working hours, overtime. One issue is how much you're allowed to work. The second one is how to be compensated. And in this one, we have a word on the left side here, which is called flexity. It's a very common word, you know, it's called time account. So overtime is when your employer tells you you have to work. That's pålagt overtid. It's when you're told you have to work, we have to finish this project, you have to work. If you have an agreement with your employer where you have typically you have a core time, 9 to 3. And when you come and when you leave outside that, it's up to you. And then you have an account and you have to work typically 40 hours a week or whatever per month. That is not considered overtime. So there's a huge distinction. So you're not going to be compensated for that because first you decide yourself when you come and go. So it's not instructed to you. And the second is kind of the point with this system is to give that flexibility, which many employees are coveting. And so this is, but it has to be agreed upon in order to be very precise. And this is to avoid any misunderstandings from the employer as well as the employees. So it's kind of, you can't just say to yourself, well, I'm implementing flexitid on my own. Your employer might have a saying about that. And of course, it's depending on profession. If you're working in the in a shop with opening hours, then of course this doesn't apply. But if you have a working place where exactly when you're at your desk is not that important, this is very common, and it's considered a benefit. It's considered to be something of value to the employer because you have control with your working day. So again, flexitid does not equal overtime. Flexitid is something you control yourself, and overtime is something your employer is telling you to do. So let's move one more. Did we lose Cassandra? There we are. Salaries. Yeah. People tend to be interested in this topic. First surprise, we have no minimum payment in Norway. That's the general rule. If I agree with one of you to work for €1 a day, that's actually within the law. we have no minimum payment. And that sounds a bit odd because Norway is kind of a welfare state, and we are kind of very strict on everybody having a salary from which they can live and whatnot. And the reason why we don't have a minimum pay in Norway is simply that, and the argument is that if you have a minimum pay, it also tends to be the pay. And as an economist, I can say to some extent that's right. If you look at the US, where minimum pay is kind of both on a state and federal level, frequently you will find that minimum pay tends to be the actual payment in a business. So that's the reason we don't have it. However, first we have tariff agreements which do apply in a number of industries. I mentioned construction industry and so forth. And of course, the moment you're organized, if you're organized in a union, that also is an important thing. But you're actually mandated yourself to take care of this. So when you enter an agreement, if you agree to a salary which is low, well, that's actually your headache. It's in principle, you're allowed to agree that with your employer. So take care of that when someone is offering you a job, whatever. There's no automatic solution where you can say, oh, I'm underpaid, I'm going to go to court and be correctly paid. That doesn't actually apply, with these exceptions I just mentioned. But then, of course, we had this exemption with the specific industries, construction industry being the most famous one. And then we also have a EU directive, and it's called the temp directive. And that is basically the following. If you're a temp and you're working in an organization, you're not to be paid less than anyone with a similar job in that organization. That's kind of the very short version. So if you're a temp, you're hired, you're kind of working for a staffing company, and you're sent out to a construction site or whatever, then you're supposed to have the same pay as everybody else in that organization doing the same job. So that's the one exception from that. There is no minimum payments rule. So if you're a temp in any sense of the word, then this applies. But question again is the same. What is a fair pay? What is a correct salary? What should you ask for if you're offered a job? And of course, you don't know. Well, happily, we are country statistics. We have the Central Bureau of Statistics are making statistics on, you wouldn't believe it if you go in there. And you can find statistics for different businesses, different areas of industry, of different educational backgrounds. And of course, again, unions, they have statistics for the members. So you can quite easily find out what is the normal pay for a carpenter, a maid in a hotel, a cook, an architect, an economist, whatever. You'll find pretty good numbers for every one of those. And that should be a good starting point if you're uncertain about what you are to ask for, or if the offer you have been given is fair or not. That being said, however, and this is where I'm really give my compliments to today's host about what she's doing, is that we are very poor in Norway to appreciate the pool of talent we have here from different parts of the world. it's a consistent problem that very skilled personnel are coming to Norway for various reasons, and they have a very hard time to find jobs matching their skills. For some reasons, we're very chauvinistic in this country. If you haven't gone to that business school in Norway or whatever, I mean, of course, if you've been to Harvard, no discussion, but I'm always puzzled and surprised to see the challenges facing people of talent and education coming to Norway from abroad. And I'm sorry to say, we are chauvinist. We are not that global in our mindset as we should be, and has to be adjusted also to say that for some industries like oil and gas and IT, of course, different story, where English is a working language. But my general observation is that what they're offering you is, of course, based on skill. Language is a key. An employer will frequently argue that, well, you don't speak Norwegian, so sorry, then you should be paid a bit less. That could be an argument. And there's no illegal restraint to say so. I mean, of course, it's also kind of a factual thing. If you're working with customer support, Norwegian is a skill you need to have. So I would just encourage everyone, if you're working in an area where language is a kind of an obstacle, a barrier, then find the nearest class and work on it, because that's most likely the quickest way to kind of get on board with the rest of the workforce and not feel like you're being treated like you're not really there. So that's just my general observation. And well, I'm hanging that at home. My better half is American, so yeah, we have seen this close-hand a number of times. So summarized, no minimum payment. You're free to read what you want. In a number of areas, we have tariffs regulating. For temps, there's a special exemption. And if you're not certain, statistics. And again, if you're not certain, ask union, ask friends. Don't think that the offer you're being given is necessarily the right one or the fair one. So, Cassandra, should we take the next one? Thank you. Yeah, this is the unpleasant part of being an employed. And of course, we're talking about termination when it's not wanted. This is more like all over Europe. As a general rule, the employee has a rather strong position. It's considered to be the law is to protect the employees because they're considered to be in the weak position versus the employer. And of course, there's nothing to discuss there. That's the way it is. So that means that when someone wants to terminate an employee, an employee, there are quite strict rules, and this is the main reason I go to court for clients who are corporations that haven't done the homework. So, but the general rule is that there has to be factual reasons. It's not like in the US, where I don't like your face, go, 14 days you're off. That's not the way it works in Norway. You need what's called a factual reason, and that can be anything from underperformance, mismatch when it comes to skills. It can be less activity in the company. We have to reduce the workforce. It can be like COVID typically, and then suddenly you have a massive change, then you don't have work for people. But there has to be a factual reason. And if that factual reason is related to your performance and that they don't think that you're sufficiently competent or whatever, there are also requirements to how that is to be mitigated, because they have an obligation to try to give you that skill they think that you're lacking, or to improve your competence in a specific area. And only after having tried that, they can move on. So, and this is a scenario, if they haven't done the homework, if they don't do as the law requires them to do, well, then the termination is actually void. And that's a surprise to many employers and also to employees, to be brutally honest. They're not aware of this. And of course, if it's not your area of expertise, why should you? And it's also important to remember that if you're given a note of termination, then you also have the right to contest it. There is a rather short time window, just a few weeks, where you have to contest it. But if you do so, you're actually having the right to remain in your job until it has been adjudicated by court. As a general rule, the employer can go to court and ask for a temporary ruling that you're to be sent home, and it's depending on, of course, the reason they want to terminate your contract. They can have it, but is a general rule, you're actually allowed to stay in your job until this is finalized in the court. And that can typically take 7, 8, 9 months. But there is also a second kind of termination, which is called immediate dismissal. And that's when you have acted grossly negligent in your work. And it's not like a specific, this is A, B, and C, then automatically you're dismissed. But of course, if you're physically abusing someone in a workplace, then obviously that's a challenge. If you're disclosing information which is to be confidential, that could also be it. If you're working if you're a pilot on a plane and you're smuggling alcohol to know when you're coming back from Germany, whatever, then definitely you're at least having a challenge there, and so forth. So it's kind of, we can all imagine what it is. It's requiring gross negligence of your obligations to your employer. That is kind of the wording of the law. And then you have to leave your workplace immediately, and you do not have the right to remain in your job until it's been disputed. You can still dispute it, and but you don't have the right to remain in your job. And then of course you can think that, oh well, then it's very tempting for an employer just to claim that and this just send you out the door. But the problem is, by doing that, he is then also taking the risk of, because if you then go to courts and file a complaint and you win, you will not only have to compensate your financial loss. This is one of the few areas where you're also going to receive tort compensation for non-financial losses. So there is a penalty there if the employer is kind of misusing and abusing this instrument. And again, as I said, this is an area which is extremely regulated, and mostly it's a challenge for the employer. But it's very convenient to know about your rights as an employee as well. And again, if you're experiencing this, there are a few things to think about. A very classic story is that they're trying to give you a piece of paper where you both agree that you're terminated immediately. And if you sign that paper, then everything is off the table. Then you have signed off and you're off. There's no way to get back again. So whenever you're pushed into a room and they flip this on the table, I want you to sign, the answer, I have never seen an exception, is I will take it home and consider it. And then you call us or someone like us. They have no right to have you sign that there and then. But it's a very common way to do it, because the moment you sign it, then it's a mutual agreement. And then all these other things I talked about, they're out the window. Then you have agreed on the termination. And the worst part is actually, if you do so, you can also risk to have a quarantine when it comes to benefits for unemployment. So again, this is a very specific thing which happens all the time. If it ever happens to you that someone is putting this paper in front of you and says, sign here right now, don't, period. Then we're back again to get assistance. And if you ever experience a unwanted termination of employment, always ask for assistance. And you're on a deadline here, because you have to file or contest it within a rather short time, 3 weeks. So it's not like you have months to kind of consider. So this is the case where you have to act rapidly. Happily, if the employer is not following the rule book, as I said again, things are void, and then suddenly there is no time limit for contesting it. So that's the problem for the employer. But again, this is an area where you absolutely want to have assistance, because even though you have a strong position from the legal framework, it is important to know exactly the deadlines and how to contest it, and to kind of consider your case. So I think we are a little bit on time schedule, so we have to move on. Cassandra?
Yeah.
Thank you. I mentioned labor protection law and being strictly enforced. Happily, again, this is for the employer when it comes to whose headache is this. And when I say strictly enforced, it's actually, we're talking about imprisonment. There was a company in Oslo who had a contract for renovation. And to be really honest, they were sabotaged by their employees, actually. They were sitting in the cars, not working, and to cover and to be able to do the job versus the municipality, they had to use extensive overtime, and too extensive. So the CEO of the company was actually sentenced to, I don't remember, I think it was 3 months in prison for violation of the labor protection law. So this is not a joke. More commonly, of course, you have a fee. So a classic one, and I'm building a house actually. So my contractor, he needs to have a toilet facility and a dining facility on the construction site. If it doesn't, you will have 150,000 krona fine. And so it goes. So it's kind of, this is an area where there are heavy penalties for not complying. So if you're working in an industry where this is a problem, then remember, it's actually your employer who is keen to keep this in order. And if it doesn't, well, then again, the consequences can be severe. Of course, workplace safety is a classic story, and of course, we'll think about construction industry and whatnot. But this is something which is implemented in all areas. And if you go, for instance, to an oil company, they will have a huge screen when you're coming into the. If you go to Equinor, I think it was, they have a huge screen. Last how many days there's been since the last major incident, and they try to make that as long as possible, because this is something which has been the focus of the employee of the authorities, and then also of the unions, and every serious employer will also have the same. So this goes for everything to having protective gear, boots, hard hats, whatever on a construction site. So if you go in there and you see, oh, do I have to wear it? It's like, yeah, because if not, he will have a problem. And but it's not just physical safety. You're also entitled to be protected against bullying and mentally abused by your colleagues, and of course your superiors. Of course, this is much more complicated to prove, so it's not like straightforward. But we do also have these whistleblower protections here in Norway. Sadly, they're not as good as it should be. But if you see something like this and you're notifying the authorities on it, it's a specific regulation to at least try to protect those who are telling about it. And we're back again to overtime, termination of employment. This is also, it's all in the same law, actually. So labor protection law is called Arbeidsmiljøloven. It's actually the Labor Environmental Act. So that law is to take care of everything from vacations to overtime, to work safety, to when you're sick and whatever. It's everything is put into it's one huge piece of legislation, and most of the things related to being an employee is going to be found there. And then, of course, it will also be found in other laws as well. For instance, sick money, which we're talking about in a second, is of course in a different law as well. But this is kind of where they put everything in. So this is everything from hard hats to overtime payments. It's basically here. Cassandra? There we are. Sickness. Yeah. When do you need sick leave for a physician? Well, first, you're only entitled to get sick money as a compensation from when you're sick after 4 weeks of employment. This doesn't mean that you have to be 4 weeks in that particular employer, but when you're starting a job, for the first 4 weeks, you're not entitled to any compensation. Then after that, as long as you have a continuous work record, then you're entitled. So even if you change an employer, if you go from one to the next one, you don't need to start up again. It's still, then you're still kind of in the run. But if you have a pause between two employers, then you have to kind of restart the clock. You're giving 100% compensation, but by law, you're only entitled up to 6G, which is approximately 600,000 kronas a year. And that's kind of regulated, that G amount is regulated every year. So if you make $1 million a year, the last 400,000 is up to the employer to agree with you if you're going to have it or not. If you work in a huge company or you work in the public sector, that's common. Small companies, they're not so happy about that. So this is something you have to consider when you're taking a job, is to check out these things too. Especially, I mean, of course, if you have a high salary. But then you're given this, and as a general rule, it's maximum 1 year, and then other rules apply. You can have what's called egenmelding, which means self-reporting, up to 3 days, and that's like 4 times a year. That's kind of the general rule. And that means that if you're sick, like you're having the flu, whatever, you don't have to go to the physician. You can just go 3 days based on your kind of reporting yourself to your employer. It has to be said that that's only after 8 weeks with a new company. So if you change jobs, the first 8 weeks you actually need a sykemelding, but apart from that, it's you do it for you just send a notification and then you can be sick for 3 days. This is 3 calendar days. So if you're sick on a Friday, on Monday you have to be back at work, or you need to go to a physician to have your sykemelding. And this is kind of reflecting on who is paying what, because 16 first days is paid by the employer. If, as I said again, there's a 52-week maximum duration, and then you have to be out of it again for 6 months until the clock starts again. And if you're sick beyond 52 weeks, then there is a different compensation, which is much lower. So if you get serious condition like cancer, whatever, this is actually something which is problematic because cancer treatment typically takes more than a year. And this is one of the weaknesses of the system in Norway. After 8 weeks, the NAV is going to contact both your employer and yourself. And then they're going to put much more focus on trying to get you back at least partially to work. And one of the reasons for that is that we know from experience that people who are away from work for a long time have a tendency to drop out of the workforce. So to keep employees in the workforce, there is a focus on getting you back again, at least temporarily, at least starting with 25% or whatever, just to get you back starting to work. Or the employer is also obliged to try to adapt the workplace so that you can work. So if you have a broken leg, well, then you should have a chair and whatever, a desk for that. Or you could be reassigned to other jobs if your present job isn't compliant with the condition you have. And then there's a high probability that you will be called into a meeting with both your employer and them, and then they will go through this, and your employer is obliged to make a plan. And if he can't do that, he has to explain why. And that brings us to the last one, who's paying. Normally, your employer will pay you that, and he will be reimbursed after 16 days. But it's not always the case. So if your employer doesn't pay it, you have to apply directly to NAV. And I can say immediately that's a slightly bureaucratic process. But again, they have an online site solution. It's bilingual, both Norwegian and English. So it is doable. But again, if you have problems navigating whatever, this is of course where my colleagues, for instance, working with NAV cases only, can step in and give you a little assistance. Because the first 16 days is from your employer, there's no discussion. But after 17 days onwards, it's NAV. And if he doesn't kind of pay you and then he gets reimbursed from NAV, then you have to go directly there. So this is a bit cumbersome if he doesn't do so. And this is also something you can discuss when you're starting a job, just to clarify. It's not like we are planning to be sick, but it's always nice to know how it's working. Cassandra? Was that the last slide? Here we are. We're running a bit out of time. We're going to have a Q&A. Vacation. Yeah, Norway is actually one of the places in Europe where we're the stingiest when it comes to vacation. By law, you're only entitled to 4 weeks in a day. However, it's common to have 5 weeks. And then we have this very strange system called feriepenger, vacation money. Normally, you get paid vacation days in Germany, whatever. Now we have the strange system where you're kind of earning 10.2 or 12% respectively of your salary, and that is to be paid out the year after in June. And this is a classic, no one understands why it's like that. So when you start a job January 1st, and you come to June, you're not entitled to anything for that year because you didn't work the previous year. Only the year after will you be compensated in June for that, which is 10.2% if you have 4 weeks in a day, or 12% if you have 5 weeks. And that will be paid out in June. Then, of course, you don't get a salary. So it's kind of, you have 11 months of salary, and then you have a month of vacation money. And this is a nightmare for both employees and employers. So this is kind of a tricky one, and where people stumble a little bit and so forth. So again, if you're starting a job in Norway, and this is your first job in Norway, the first year you won't have paid vacation, period. And that is a surprise to many. So just keep that in mind if you're starting a job in Norway. It's also if you've been out of the workforce for some time and then you go back again. So the first year, that summer, you won't get money. And again, it's paid out in June, and typically it's exempt from payroll tax, so you get the entire amount. And then, of course, when can I have my vacation? And this is an area where the employer actually has a lot he can do. You're entitled to have 3 weeks continuous in the period between June 1st and September 30th, I think it is. And then everybody says, oh, I got kids in school or whatever. And of course, your employer normally will try to cooperate. But if that's not possible, he can actually tell you to have your 3 weeks from June 1st until June 21st. That's it within his rights. And then you're entitled to have at least 7 more days continuously sometime during the rest of the year. But it can be convenient to have this discussion also when before you're signing off a contract, just to have kind of an agreement on this, because people are a bit surprised to know that the employer has a very strong right to dictate when you're going to have your money, your vacation within these framework parameters I just mentioned here. Okay, Cassandra. So finally, we talked about a lot of things here. Disputes. Again, a lot is regulated by law. That's the upside. And the law is focusing on the fact that employees are the weak part, employers are the strong part, and it's made to kind of protect the employees to a large extent, both when it comes to overtime, when it comes to safety at the workplace, when it comes to termination of contract, and so forth. So much is regulated by law. And then again, back to what I just said, I'm repeating myself again here. But if something pops up, don't sign anything without getting some advice, unless you're very sure about what you're doing. It's a common tactic for employers to be, how to put it, operate a bit unethically. They're trying to bully you or kind of being a bit abrasive, whatever. And I have so many cases I'm starting there. Because even if you're feeling strongly pressure to sign something, all hope is not out. It's just, it's much more complicated for me to kind of get you back in again. So even if you feel a pressure, it's like 3 big guys hanging over you and whatever, it's like, okay, and you signed it. So still do have a conversation with it afterwards. But as a general rule, it's easy to avoid problems if you do not sign any kind of agreement without having advice. Legal cost. Yeah, general rule, you have to pay yourself. If you win the case, typically you have a termination agreement, then the other party will have to pay your cost. As a general rule in Norway, if you're losing a case, you will also carry the cost of the opposing party. So that's always the risk when you're going into a legal dispute in Norway. However, for employees, it is generally not being awarded even if you lose. That means that even if you lose it, your employer will not be entitled to having his cost covered. That's kind of a general rule. There are always exceptions. So it's not like a slam dunk. But again, this is because you're considered to be the weak party. That, however, doesn't mean that you're going to have your legal costs on your own side paid. There are insurances who can step in here, and of course different union memberships and whatnot. But of course, legal disputes are costly. However, the initial steps are not that, because normally it's unbelievably how much a letter from us can accommodate. Because again, to be brutally honest, many of these employers are not that, they're kind of going out loud and screaming, and then when they meet some resistance, they're kind of crumbling. So it very frequently just take 1 or 2 hours, and then we settle it. And settlement is the normal way out, because employers know that they're not having a strong case necessarily in court. But if it does have to go that way, then we have different ways of mitigating it. And we have what's called forliksrådet, literally speaking, the settlement council, which is a low threshold, low cost solution where there are a panel of 3 who are non-professional judges, and they're adjudicating in predominantly cases where we're talking about money. So that's a starting point. That was like 800 crowns, whatever it is, to kind of file your case, and you don't spend a lot of money. So that's kind of the low cost entry. And then if you win, then it's depending on the amount of money. If it's below 250, then that ruling is there, and then they have to appeal it to the courts. If it's a huge amount of money, however, and if the other party do not agree to kind of settle there, then it's going straight to the next court, because they can only settle cases up to 250,000 crowns in value. But if you're disputing like you weren't paying your vacation money and so forth and whatever, then you can go there. And then there are also some other instruments that can be used to put pressure on employers. So there's a lot of things we can talk about there, but one of them, which is frequently very efficient, is that normally when you want to bankrupt someone, if you haven't been paid, and you go to the courts and say, I want to have this file bankruptcy for this company, they haven't paid me, and they don't seem to do so, you have to pay 60,000 kronas to as a guarantee to cover the cost of the bankruptcy in case the company question has no value. But if you're an employee, you're exempt from that. So it's a very low threshold for an employee. If the company doesn't pay your salaries and whatnot, is actually to go to court and file for bankruptcy. And my experience, that is a very expedient way of getting people to pay with their money, because bankruptcies are in Norway, it's not a pleasant thing. In Norway, probably one of the worst countries in the world to have a private bankruptcy. People are not quite aware of that, but that's also one of the reasons. If you ever want to start a business, for God heaven's sake, make it a limited liability company, ARS, and not a enkeltmannsforetak, because you do not want to be have a personal bankruptcy in Norway if you can avoid it. So summarized again, lots are regulated by law. Anything pops up, don't hesitate. Get advice. If it's from us or uni, whatever, it doesn't really matter, but have someone there who knows what they're talking about. Legal costs, initially you have to pay your own, but if you lose, you still haven't, most likely you won't have to pay the other one. And if you win, they will pay your cost. And finally, forliqsorder is the low cost entry if you want to have disputes. But if it's a substantial amount of money, you have to go to tinget. Cassandra, I think that was the last one, was it? Yeah, there we have it. So 90 seconds about this. We are cooperating with a lot of partners, and it's a combination of organizations for various purposes and various interest groups for various foreign interests in Norway, being chambers of commerce or employees or employers. So this is kind of a little overview of with whom we're working. And we are working with predominantly small and medium-sized companies. That is our strategy when we're working with corporates. And then we work with clients from all walks of life and all backgrounds and nationalities and cultural backgrounds. And again, that is also mirrored in the composition of our staff. So should we take some quick Q&As here?
So thank you so much, Stana. That was really, really helpful. And I know it's almost 3 o'clock, but I thought if you also have time, there's a couple of questions that we want to go through, and we can just record this in the webinar, and we can upload that on a YouTube channel. So for people that have to leave now, don't feel like you have to stay, because we will record the responses. Okay, perfect. So the first question here is, I can see your hand there. I'm just going to get the questions first. This is from Suzanne. So what's the sanction for the employer if there's no written contract?
The sanction is depending a little bit if they're consistently ignoring that or not. We're talking penalties like it's a fine mostly. That's the general sanction if you're violating. The problem is that not having a contract is kind of a penalty in itself for an employer, because the moment it doesn't take a lot to establish that you're an employee, and he's kind of losing all the possibilities to get a contract which is flexible to him, because then by default it's a full-time contract, 37.5 hours a week, no flexibility, no exemption from overtime. So it's actually the employer who is having the general problem. And again, I just had this client in court, and without going into detail, that if he had agreed, for instance, on a time account, then lots of problems would go away. He hadn't. And that's one of the reasons we were there. So sanctions are fines, but again, most of the time, most employers are not aware that they actually have a problem. The moment you have received one payment on your account, it's very hard for an employer to say, I've never heard about that person. Oh no, she's never been here. It takes up very little to document your job if there is no contract.
Okay, thank you, Steinar. And the next question is from Charu. Is there any provision where we can claim the double taxation relief?
Yeah, it's depending on where you're coming from, where you're living, tax treaties and whatnot. This is it's very individual. So this is something which is kind of hard to say on a general basis. But if you experience double taxation, as a general principle, it's regulated by the tax treaty between Norway and the country in question. And normally what you get is a credit in your primary location. So you're kind of getting a deduction on your taxes there. But this is a very complicated area. So it's kind of hard to give like one answer that will fit everybody. But then again, if this is a case for you, then just come by. We'll look into that for you and fix it.
Okay, thank you. And someone is raising your hand. I can't see your name, so just feel free to ask the question.
My name is Sadie. Hi, and thank you for your great presentation. Thanks for the time that you put on your presentation. That was so useful. The question is, you talked about holiday payment, feriepenger, that we get it on June. and if we start the job at the same year, we don't get it. But the question is, if we work at July, do we get the loan or not? Or is it considered as our time that we worked or not? I don't know if I put it in the right way, if it's understandable.
If I get you right, if you do not take a vacation, are you then paid in June, basically? Yes, you are, period. Because if you do not have vacation, of course you're paid. That's no discussion. So if you do not have any vacation, yeah, then you're paid for it.
So it's possible to get the payment for all the 12 months, even though you didn't get any vacation payments.
Yeah, if you don't bother to have vacations, then then of course you have to be paid for 12 months. That's a very good question. Actually, it's not like you're working for free, but most people like to have some vacations. And that's more common, because the question is, you're getting paid, when are you getting your vacation money? If, for instance, you have your vacation in August, then you have these kind of how do you do that? And most employers would just say, well, we pay you vacation money in June, and then you're not paid your salary, but then you're working in July, and you also paid your salary in August, even if you're away. So this is more like practicalities, but you're entitled to be paid for your work, period. That's just like, don't worry about that.
Thank you.
Anytime.
Okay, and then the next question is from Marius Jennings. So are you entitled to a temporary D number while you're waiting for UDI to review your temporary residency permit?
D number is, again, it's depending on your status, where you're coming from. If you're EEA citizen, it's a huge complex matrix. But a D number is something you can get rapidly if you have a job. So if you have a work contract, that's basically starting point. So if you have someone's offering you a job, then you run down to you get an appointment, you run down, you identify yourself, and if you have temporary stay and you're allowed to work, and now again, this is why this is just going to be more like a general answer. And if in your specific case, you have to check out exactly how it is, then that is what they require for you to have a D number. You need to have a reason to have it, and having a job is one of them. But again, if you have a status which is not clear yet about why you're here and your residency and whatever, then again, this is where we come from. So one of my colleagues, Tveter, who's one of the named partners, he's one of the most experienced people in Norway on immigration law in general. So absolutely, if this is a problem or a question for you, then come by and we can look into that and see how it is if you don't already have legal representation.
And from Anna, are there specific rules for contract temps working for an agency?
This is an area where I would be very cautious about saying something, because it's changing as we speak. The new government the program of the parties in control are very how to put this, not friendly to the entire temp industry. The general rule actually in Norway, a job is a full-time job, period. And every exception from that is going to be, you need to have a formal reason for having that. And it used to be strict, and it was a bit more lenient with temporary employments and whatnot, and hence, and of course, also temp works. And then now we're expecting a massive change in the other way. The funny part, of course, being the by far worst player in the market when it comes to having not full-time jobs is actually the public sector. If you're a nurse, you can be offered a contract of 1.9% of your working hours. So you have like 2 hours of fixed, and everything else is depending on whatever they need. If you're working if you're an academic, you will notice that you will be way into your 40s until you get a fixed position. So the funny part is actually that the public sector, which is of course directly under control of politicians, are the one mistreating their employees the worst. But in general, no. If you have a contract, it's no specific provisions which are kind of different. If you're as such, no, again, general rule. If you're a temp, you're employed by your employer, and the question is, does it state that you have a fixed job? So you have like 40 hours or 37.5-hour a week, so you're paid full regardless of. And this is what is important for you, is to have a contract which states that you are going to be paid regardless. So it's depending on who's going to carry the risk for them not finding something for you. And what we call 0-hour contracts are really under attack. And from an employee's standpoint, I can totally understand that, because you have no security for having anything. You're kind of committing yourself to an employer, but he doesn't offer any kind of security for you having any work in return. So this is an area where I would definitely focus on that part, and that's the important part, that you know that you're paid even if suddenly your temporary assignment is terminated and you're waiting for something new. But again, this is a thing which is to be negotiated between the parties. So if you feel uncertain, we are here, unions are there. There's a lot of sources where you can go and get guidance for this.
Yeah, perfect. And then Suman, does a special provision for commuters apply only to people who commute internationally, or also to those who commute to a different city within Norway?
No, it's actually the opposite. The default is that you're commuting in Norway. Commuting in Norway is very common. Then, of course, because we have international obligations, we have to provide the same benefits, so to say, for those. And so the rules are basically the same, but the most common one is really Norway. And if you're working in Norway, you actually have some benefits in the sense that we have, for instance, if you're traveling for your, well, this is a bit opposite. If you're traveling in your work and you're staying with a friend, then you can be given a 425 kroner compensation tax-free if you're spending the night. If you go internationally, if you don't have a receipt from a hotel or whatever, you're getting nothing, for instance. So it's actually more focused on commuting in Norway. So the most important thing to keep in mind is that you need to have a minimum number of travels home, and those you have to document depending on your family status and whatnot. And yeah, so it's again, it's a bit of an individual situation, but yes, it's absolutely, commuting is very relevant if you live in Norway. I just mentioned that because I know a reason that quite a few of you were you're commuting perhaps from abroad into Norway. So, but yeah.
And Anna Clara, is there a reason why wages are not usually advertised on vacancy ad?
Yeah, that's a very good question. It's depending. In public sector, frequently they are, because every job has assigned a salary span. So if you're applying for work in the municipality or in the county or in state level, and national level, it's kind of, most of the time you'll find that there is a salary span depending on your experience and whatnot. But there are exceptions, and that's simply because that most employers will say that it's depending on your skills and the competition and how hard it is to find. I mean, we don't know yet. We're going to have a lawyer. So what do we pay? Well, it's depending on who we get. What is your experience? How good are you, and whatnot? So they make an individual assessment. So that's why you will most of the time not see that. I know that foreigners think that's a bit odd, because if you go to the UK or wherever, it will always be kind of a indication of where you are salary-wise. But that's true. That's very uncommon in Norway, with then this exception in the public sector.
If I can just add something there as well, Steinar, going back to Anna's question, we do see that there's more and more companies in Norway that do advertise with salaries now, and it's becoming more and more common. Particularly talking for the startup and the scale-up ecosystem, where you see that they want full transparency. So you do say it's coming more and more common. And Sarah, is there any opportunity to find a job for a person who has no previous work experience with A2 level in Norwegian language? I hold a bachelor degree in accounting. That's probably a question that I could answer.
I was just thinking about the same, actually. This is for years.
Yeah. There is an opportunity to find a job, Sarah, if you don't have the language skills at the same level as someone who's obviously from Norway. But it just depends on the sector and also where the market is. Obviously, if the target is a Norwegian clientele, it's a little bit more difficult. But like what Steinar was saying, we really recommend you to learn the language. We don't tell any of our candidates not to learn it, because you are in Norway now, so it's expected that you learn the language. But there are also jobs out there that are in English speaking. So it just depends what kind of opportunities that you are looking for. But both English and Norwegian are available. And I can send you more information via email as well after this webinar.
Just a general thing, remember, everybody started without experience. That's, always keep that in mind. You're not the only one. So even though employers like to have someone age 25 with double masters and 15 years of experience, that doesn't exist. So everybody starts at scratch somewhere, and don't be terrified or kind of put off by that.
Yes. And Suman, is the sick pay valid only if we get sick during the days we're assigned work? For example, what is the provision like for interns and part-time workers? Employees might say that you didn't have a shift on that day, so we don't need to pay you. Is that allowed?
Correct. This is very much depending on exactly what contract you have. So we're very careful about going into details, but sick pay is to compensate for a loss of income. So if you are sick a day and you were not supposed to be paid that day, then of course you haven't lost any income. So that's the general principle. So that could be the case, but this is very complicated. It's depending very much on your agreement. What is more is the question I get more is actually, we have some provisions, for instance, what happens if you get sick during vacation? How's that working? And there we actually do have provisions that if you're more than so and so many days, then that's considered to be not vacation, then you can retake your vacation, whatever. There are some provisions there, but as a general rule, if you haven't had a loss due to you being sick, then there is also nothing to compensate. That's kind of the general approach. So then it's up to the individual case, and then you would have to look into it.
And another question from Anna Clara: vacation when you work for an agency, does it apply? What happened if you work for an agency and the company closes for holidays?
I'm not quite sure I got the question. Is it like you have to take vacation those days, or if you're paid? I'm not quite sure what you're asking about.
Yeah, I think if I understood it correctly, I think she's asking if are you forced to take holidays when the agency closes? So do they force you to take the holidays?
That could be the case, yes. And that's a classic dispute between employers and employees, is that it doesn't suit you to have the vacation then, typically if you have kids in kindergarten, schools and whatnot. Sadly, quotation marks, depending on how you look at it and from whom you're coming, it's the employer's decision between June 1st and September, as I mentioned, to decide when you're going to have your 3 weeks. You're entitled to 3 weeks continuously. So they can't say 1 week here and 1 week there. But if they have to do the beginning round, that's actually up to the employer. So if they're closing down for 3 weeks in the summer, and they say, well, this is when you have to take a vacation, he's actually entitled to do that. Mm-hmm. And actually in Norway, we have what's called an industrial vacation. It used to be in the olden days that actually almost all of Norway closed down at the same time in July. So that was, but now today, of course, the economy has changed a lot. We don't all work in industries and so forth, because that was the reason you couldn't have half the staff in an aluminum factory. That didn't work. But there are still remnants of that. So, but in general, the employer decides.
Mm. Thank you, Steinar. I think we've gone over the time, so 15 minutes. So what I would suggest would, if it would be okay for you, Steinar, to reply to some of these responses, because there's still a lot of questions left. If we can send everyone an email with the responses, since we've already gone over time. Would that be something that you're okay with?
If you can put them in one email and send them to me, I would love to do that.
Perfect.
Brilliant.
Okay, let's do that. Thank you so much to everyone for being here today. And also thank you so much for Steinar and Cassandra for taking this time and opportunity to, giving everyone this webinar completely for free to give you a better understanding of, what are some of the expectations of people that are moving to Norway who maybe doesn't have an understanding or knowledge about, salary expectations, sick leave, pay leave, and so on. So we will answer all of your questions via email. And once again, thank you so much for being here. And we will upload the recorded webinar on our YouTube channel on Skillhus. So once again, thank you so much to everyone.
Have a nice day.